Article 4's Privileges and Immunities Clause, also known as the Comity Clause, prohibits state governments from discriminating against out-of-staters without substantial reason when denying certain rights to people. The nation's highest court considered whether a residency requirement for bar admission on motion violated this clause in the 1988 case Supreme Court of Virginia v. Friedman. Myrna Friedman was a lawyer and a member of the Illinois and District of Columbia bars. For several years, she worked for the Navy in Virginia, and for several years after that, she was in private practice in D.C. In the mid-1980s, Friedman became in-house counsel for a company in Virginia. The following month, Friedman married and moved from Virginia to her husband's home in Maryland, keeping the same job. 4 months after that, she applied for admission to the Virginia bar on motion, meaning that she applied for admission without sitting for the bar exam. Under rules created by the Virginia Supreme Court, lawyers licensed in another state could be admitted to the Virginia bar on motion, but only if they were permanent residents of Virginia intending to practice there full-time. In her application, Friedman recognized that she lived in Maryland. She argued that her application should be granted anyway because she would be practicing in Virginia full-time, be available for court appearances and service of process, and educate herself about local rules. When the Virginia Supreme Court rejected her application, citing the residency requirement, Friedman sued in federal district court, arguing that the requirement violated Article 4's Privileges and Immunities Clause. The district court ultimately entered summary judgment for Friedman, and the Fourth Circuit affirmed on appeal. The Virginia Supreme Court appealed once more, this time to the United States Supreme Court.